All right. So I wanted to take a minute to talk about um, this article here that Emerson sent me earlier, because I think it's pretty important. The ICWA, which is an act that let's see how to describe this. Well, let's just get into it, and hopefully I'll be able to illustrate why I think it's important as I go through the article here. Um, so in Nevada, it might be in the entire country, but at least in Nevada, they have this law where if you have a baby that you can't take care of, you can leave it at a hospital, and you know that's how you it's I think they get put up for adoption or they go to an orphanage. I'm not sure what happens, but you leave your baby at the hospital. Um, so let's see. So this baby, Octavia, was left at, yeah, it is Nevada. Okay, Nevada's safe haven law was left at the hospital, and they were picked up by Heather and Nick Libretti. Um, and Heather and Nick Libretti have adopted kids before, and this was going to be, I think, their third. So let's see. Yeah, they adopted two boys and taken in a third. Uh, so Heather would be their fourth, then I guess. Um, so Octavia's mother, when when she dropped off the Octavia, relinquished her parental rights in doing so, and did not share the father's name with hospital staff. So there wasn't any biological family to claim her. So the Librettis thought that they would be able to adopt her. Um, but a few weeks later, her father's name was found. Um, it's not sure, not clear how, but he was contacted, and after there was DNA confirmed the paternity, so there's like did a paternity test. Um, he said he wanted to raise the child. Now he was homeless, he had substance abuse problems, and the Child Protective Services or Human Services Agency said that once he sobers up, then they can be reunited. Now that part I think is pretty reasonable, but Octavia's parental grandmother was a citizen of the Isleta. I don't know how to pronounce that. Isleta del Sur Pueblo. Um, I'm butchering that. I apologize. They are a Native American tribe in El Paso, and that means that Octavia is eligible for citizenship in the tribe. Um, and her case falls under the Indian Child Welfare Act, which is a 1978 federal law created to prevent family separation in Native communities. Um, it's my opinion that this particular act is very important because we've had in this country a history of genocide against indigenous peoples. Um, a lot of tribes just don't flat out don't exist anymore. So in order to prevent things from getting worse in that area, we have stuff like this, the Indian Child Welfare Act. So this law gives Octavia's tribe the right to intervene in her case, and it required the social workers to prioritize placing Octavia with extended family members or other members of the tribe. Uh, and the social workers at the tribe told the county they would only intervene if the child wasn't placed with relatives. So that meant that her placement with the Librettis would be temporary. Now, the Librettis didn't really take kindly to this, and they fought it, and eventually they won. They ended up adopting Octavia, but they didn't stop there. Um, they joined a federal lawsuit seeking to strike down the act entirely. The act is Howland v. Bracken, and it's at the Supreme Court now. Um, Even though they won custody uh, over the child's blood relatives, they're still fighting the ICWA because they're claiming that it harmed them so seriously it violated their constitutional rights, which is it's bullshit. They had 3 weeks with that child. So Supreme Court heard arguments on November 9th. This is from this point forward. I actually haven't read the rest of the article, so this from this point forward is going to be new to me. November 9th, Supreme Court heard arguments. It's a sprawling case, one of the most important of the term, with politically seismic implications for indigenous nations in the United States. So, in the United States, a lot of these tribes are they are how to say that they're enclaves within the United States. Like, okay, good, you're here. You can help me get this right. Welcome back. So Emson is the one who sent me this article in the first place. They know a lot more about this kind of stuff than I do. Okay, so since my chat isn't on the screen, and I will be clipping this part of the VOD later for a highlight, um, I'll just read out what Imson said here. Only federally recognized tribes protected under the ICWA. So, for example, Lumbee, only recognized by North Carolina and South Carolina, aren't protected. In 1978, the year the ICWA came about, was the same year that indigenous languages and ceremonies were unbanned. It was the year of massive change to U.S. policy towards Native nations. So yeah, that's another part of the indigenous genocide that I mentioned earlier. There was an actual ban on them speaking their own languages and doing their own ceremonies and whatnot. Hey, RX Chief, how you doing? I'm doing something a little bit different today. I'm talking about something that I think is important. I don't know if I'm the best one to talk about it, but I have been told that bringing this to a group of people that don't usually, uh, they don't usually talk about this kind of stuff with is important, and I tend to agree with that opinion. Yeah, yeah, that is fucked. It's ridiculous. There's a lot of indigenous languages that have been completely lost because of that. There's not any remaining living speakers, and there's a lot that only have a few or even one speaker, like living native speaker left. It's horrible, and there's a lot of indigenous people who don't know their own language because of this shit. Okay, so the here we go. In addition to Libres, it hinges on the stories of two other pairs of non-native foster parents who collectively wanted to adopt four native children. Chad and Jennifer Burkeen of Texas, and Danielle and Jason Clifford of Minnesota. The plaintiffs are joined trying to overturn the law by the state of Texas. Defending the ICWA are four federally recognized tribes: the Cherokee Nation, Oneida Nation, Quinault Indian Nation, and Morongo Band of Mission Indians. I probably butchered those. I'm sorry. Yeah. So something else that that Emerson just mentioned. There's a group of, I think it's called the Lakota Languages Consortium or something like that. It's this group of non-natives who have like a patent on, I think it's a patent on the Lakota language, Lakota Language Academy. Okay. Um, and they're trying to, sue the actual Lakota people for ownership of their language. It's ridiculous. Innocent says they got transferred a bunch of old recordings and writing and used it to make dictionaries they now sell back to us. Yeah, it's horrible. Uh, let's see. So also defending is the federal government. So the author of this article is Rebecca Nagel. I'm not sure how to pronounce that. I'm gonna butcher all these names. Um, so she's been following this case against the ICWA for a while now, I think. Let's see, where were we? Right. For the last 3 years, Rebecca has researched Brekeen, digging through the underlying custody cases along with her colleagues Amy Westervelt, Maddie Stone, and Anne Gray. In the process, she found persistent and troubling similarities. Two of these stories, those of the Burkeens and the Cliffords, became the basis of the second season of This Land, a podcast that she hosts. I might start going through that podcast, actually. Let's take a look at Crooked. I've not heard of Crooked. All right, yeah, I'll go through this later. It's like imagining 343 banning covenant species from speaking their native language starting from Halo 5. 343. Okay. Uh let's see. Oh, sure, yeah, I'd love to listen to him with you. So the Liberators framed their case in federal court filings. They simply wanted to give a child a loving home. That's what they say. A native child they had raised for birth. They were nearly thwarted, however, because of an outdated, ill-fitting law that wouldn't let them keep her. But like I said, they only had her for like 3 weeks before the father's name was found. So that's bullshit to me. They alleged that the ICWA violated their constitutional rights because it gave preference to Native families over them. Their lawyer, a partner in a law firm, Gibson Dunn, claims his clients were treated like fourth tier citizens, and that ICWA results in a direct disadvantage to non Indians. So I see the same kinds of arguments levied against affirmative action, and it's just as bullshit. It's just as much bullshit there as it is here. So both the liberators and their lawyer argue that the ICWA violates the Equal Protection Clause of the 14th Amendment because it discriminates against white foster parents. Uh, mm-mm. To put it simply, the liberators claim they couldn't adopt Octavia, even though they didn't. They did end up adopting her because they aren't native. It's they did end up adopting her though. It's ridiculous. So here's some more context for you. When Congress passed this act in 1978, about a third of Native children had been removed from their families and their tribes by the government. So there were these residential schools, I think they were, all across North America, where Native children were forced to go to school and forced to assimilate into the colonial culture. Oh, this is a different program. Okay. So in the 50s and 60s, the federal government sponsored a national program that actively sought to take Native children out of Native homes and place them in white homes. Okay, so the residential schools were just before this. Then they were the 1890s through the 1940s, and then in the 1950s they pivoted to adoption. Okay, more information from Imson there. At the same time, state child welfare agencies were systematically removing Native children from their families for innocuous reasons like being raised by a grandparent or just being poor. Indigenous nations and children's rights organizations warn that overturning the ICWA could lead to the loss of future generations of Native children to predatory adoption and abusive social work practices. I hear stories all the time about, kids being unfairly taken away from their parents, so it wouldn't surprise me at all if yeah, that 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 tracks with everything that I've heard and learned and observed. More from Imson. Yeah, the 50s were a restructuring period, and then the 1960s brought what Canadians call the 60s scoop, scooping babies off of reservations into the Catholic and Protestant adoption systems. I'm going to turn off those chat messages for a little bit, I think. All right, for broader historical context, I want to point out that this all arose out of the Indian Wars, like it is a continuation of wartime policy. More from Imson there. So I actually don't know a whole lot about the Indian Wars. We weren't really taught a whole bunch about that in school, so I'll need to look into that at some point. I can't find the source quick enough, but literally moving to residential schools instead of wars was a monetary decision. It was cheaper to steal babies than to go to war with the adults. Oh, wow. Okay, so the ICWA had bipartisan support and existed without much controversy for the next 30 years. Okay, more from Imson. Extermination to assimilation to termination. That's the broad view history of white genocide against natives on Turtle Island. And Turtle Island is, I think, the indigenous name for North America. Am I correct about that? First tried to kill us like pests, then tried to erase us into whiteness. Now they're trying to deplete us. Now trying to deplete us through things like blood quantum and adoption. Not all indigenous folk, but a lot. Okay. So a lot of indigenous folk call North America Turtle Island. It's a big island. So the ICWA existed without much controversy for 30 years, but for the past decade or so, it's been challenged as many times as the Affordable Care Act. And if you pay attention to U.S. politics at all, you know how much, like, how angry people were about that one. The challenges were part of a coordinated strategy to strike ICWA down that's being led by the private adoption industry, right-wing organizations like the Cato Institute, anti-indigenous hate groups, and corporate law firms. Many legal scholars and native advocates argue that the lawsuit isn't even about ICWA, that it's a Trojan horse designed to gut the legal rights of indigenous nations. And yeah, that tracks with everything that I've learned as well. It literally could call into question all of federal Indian law. Chrissy Ross Nimmo, the Deputy Attorney General of the Cherokee Nation, which has intervened in the case, told me. The potential domino effect of the lawsuit rests in the way it seeks to reframe tribal membership as a racial rather than political category. The U.S. Supreme Court, federal courts, and state courts have repeatedly said that someone's status as an Indian is not racial because it's based on membership in an Indian tribe. That is a political classification, not a racial classification. That's also from Nemo. The Supreme Court rules that the ICWA is, if the Supreme Court rules that the ICWA is unconstitutional because the librettis and their co-plaintiffs were discriminated against based on race, it could reverse centuries of U.S. law and precedent protecting rights and sovereignty. I don't know how to say that word. I know what it means. I don't know how to say it. Of indigenous nations. We're talking about laws that apply to individual Indians, possession of eagle feathers. But we're also talking about much, much broader laws that apply to tribes as governments. So issues like reservation status, land use, water rights, gaming, just about any issue you could ever think about that is a legal issue involving tribes is questionable if a court finds that ICWA is unconstitutional because it's race-based. Sovereignty. Okay. Sovereignty. So last January, with a more senior member of the firm, the Libretti's pro bono corporate lawyer. Oh, that's interesting. Their lawyer, they're not paying for representation. It's being provided. Wow. Okay. Filed a federal complaint on behalf of non-native casino developer challenging the legality of tribal casinos. Oh Lord, here we go. Challenging the legality of tribal casinos, the complaint cites a race-based argument similar to the one in Burkina. Supreme Court watchers worry that if this argument prevails in Burkina, the lawsuit to topple Indian gaming is already in the queue. So they did not approach this law firm or whatever. The lawyer approached them. That's interesting. Wow. Okay. That says a lot. Amid such heady threats, that's not a word I've seen very often, it's easy to lose sight of the stories at the center. Oh, so this lawyer has a history of doing this. Okay. Empson says, their lawyer who has been trying to overturn sovereignty for years. It's easy to lose sight of the stories at the center of Burkina's custody cases, but the stories matter because they are the basis for the claims against ICWA. In the years I have spent looking into these stories, I have found that they've been misrepresented in the media and in federal court. So, I actually haven't seen anything about these stories before, so I don't have a whole lot of context for how it's been misrepresented. But it doesn't surprise me that it has. A lot of the stuff that we're told, growing up about Native Americans and whatnot, it's distorted or just plain out false. So, yeah, Nemson says mainstream coverage is all about race when Native isn't a race. Let's see. The unvarnished versions of these stories suggest that factors other than ICWA were behind the challenges these couples faced on the way to adoption. More than that, they suggest that far from being penalized for not being native, the librettis, like their co-plaintiffs, were helped by it. Their story shows us not why ICWA should be overturned, but why the law is still needed. All right, so we're going to talk about these individual cases then, I guess. So this picture is Tehasi Hill, the tribal chairman of the Oneida Nation. Okay. I like his shirt. That's a really nice shirt. To understand the distortions at the heart of the Libretti's case, it helps to understand how the foster care system is supposed to work in the United States. When stripped to its essence, the central harm Nick and Heather Libretti claim in federal court is that for a period of time, they weren't allowed to adopt the child they were fostering. Within the broader context of foster care, however, this claim is perplexing. The overwhelming majority of children who leave foster care, some 87% in 2020, are not adopted by their foster parents. Indeed, if every foster parent who didn't adopt the child they had fostered had a case worthy of Supreme Court review, the court would see nearly 200,000 cases each year. but it doesn't because adoption is not the purpose of foster care. The purpose of foster care is to provide a safe and temporary home while social workers work to reunite the child with their family. There's a reason for this. Research shows that foster children do better with relatives and people from their community in what are often called kinship placements. Foster children placed with kin are less likely to be moved around or re-enter foster care, language in foster care for long periods of time, or have mental health and behavioral problems later. Thanks in good measure to ICWA, Native children in foster care are more likely than white or black children to be placed with kin, less likely to be placed in a group home or congregate care setting, and less likely to age out of the system. National child welfare organizations say that ICWA has become a gold standard and represents the best practices of child welfare policy. Because of this, state child welfare policies have begun to look more and more like ICWA. This is ostensibly the case in Washoe County, where the Human Services Agency says it places children with relatives wherever possible, whether or not their case falls under ICWA. Reunification with the biological parents is always goal number one, Amir Howell, director of the HSA, told Anne Gray and Amy Westervelt. If reunification is not possible at the time or ever, relatives are always second. That's the next best option because that keeps children with people that they're familiar with or have some family ties or a relationship with. From early on, however, the Librettis appeared to reject the idea that fostering Octavia could lead to anything other than adoption. The language of their own legal declaration makes clear that the Librettis misunderstood their foster-to-adopt status as guarantee. We were listed with the county as foster-to-adopt parents, they wrote, which means that the county would place a child with us only if we would be able to adopt and provide a permanent home for the child. But according to Howell, all foster-to-adopt parents in the county sign a legal form acknowledging that they understand foster-to-adopt placements are no guarantee because many things could happen during the course of a child welfare case, including relatives coming forward. Despite this, the Librettis made it clear from early on that their goal was to adopt Octavia, according to one source familiar with the situation. Several sources we spoke with said that Heather asked Octavia's parental grandmother to renounce her tribal membership so that ICWA wouldn't apply to the case. Jesus! During the first 6 months of Octavia's case, this grandmother expressed interest in fostering and adopting her granddaughter, but after talking to Heather, she got the sense the Librettis were determined to keep Octavia, one source said. At some point, she changed her mind about the adoption. Octavia's parental uncle also expressed interest in raising her and started the foster care application process early on. Everything was going through, said Leah Lopez, the social services coordinator for the Isleta del Sur Pueblo. I probably fucked that up again. But then, all of a sudden, we received a letter from this uncle stating that he had spoken to the Librettis and felt like Baby O was best with the Librettis. He withdrew. Ugh. Ugh. So, this is a photo of a native boy surrounded by his adoptive family. Perhaps during the era of the Indian Adoption Project from 58 to 67. The Librettis are not alone in turning to the foster care system as a way to adopt. Foster to adopt, as it is often called, is the latest adoption trend in the United States. Okay, Imson says, for context here, my mom was adopted away from her family in 1964. I had a feeling there was something like that had happened. A lot of people will come into our training for foster parents with the express desire to adopt. Cara Paoli, the director of... There's a lot of names in here that I know I'm butchering. The director of Children's Services Division of the Washoe County HSA said, They're really not so much interested in ongoing fostering, but it gives them an opportunity to meet the kids that are free for adoption and to see if they think it's a good fit. For Pally, this is a positive development. We love that because we want our kids to find a forever home. To understand why prospective adoptive parents would go through foster care, a system in which adoption is not guaranteed, one has to understand the landscape of adoption in the United States. While exact numbers are hard to come by, there are more people in the United States who want to adopt a child than there are children available for adoption. According to some sources, the number of prospective adoptive parents outstrips kids by a ratio of 30-1. The reasons are complicated, but there's a strong correlation between the dawn of the era of reproductive rights, when women won access to abortion and birth control, and single motherhood became less stigmatized, and the declining number of U.S. babies being placed for adoption. In the mid-1970s, about 8% of all children born in the United States were placed for adoption. Today is less than 1%. At first, the adoption industry solved this problem by going overseas. At the peak of this trend in 2004, 23,000 children were adopted from other countries such as China and Russia by U.S. parents. So, fun fact, my next door neighbor, when I was growing up, one of their kids was adopted from Russia. Let's see, where was I? In response to numerous scandals, the most extreme of which included children being kidnapped and murdered, countries started restricting adoptions by families in the United States, and the U.S. strengthened its own laws to curb abuse. Since then, the number of children available for adoption has plummeted. In 2021, only 1,738 children were adopted from abroad. At the same time, the number of children being adopted from foster care started to increase. By the mid-2000s, roughly as many children were being adopted from foster care as through private, domestic, or international adoption. From 2011 to 2019, the number of children adopted from foster care increased by 30%. By statute, the primary goal of child welfare cases involving foster care is to reunite the foster child with their family. You go into it knowing that the state is to a certain extent working against you, said Sherry Statler, who runs a private adoption agency in Texas that licenses prospective adoptive parents to foster. But the benefit, she explained, is that it is much less expensive than private adoption, which can cost $30,000 to $60,000. I didn't know that. That's a lot of money. In foster care, the state almost pays you to adopt, she says. To be sure, there are children waiting to be adopted from foster care, over 100,000 in 2020. That's a lot of children. But the influx of people turning to foster care to adopt isn't the neat solution one might think. Most prospective adopted parents want a newborn or close to it. The children who are least likely to be adopted from foster care are older. The heyday of international adoption saw a similar problem. Children who were older, sick, or had disabilities waited in orphanages, while younger, healthier children were taken from their families by methods that were often coercive and sometimes illegal. There is growing evidence that a similar mismatch is arising from the foster to adopt system. Of course it is. One statewide child welfare administrator told me her department had stopped recruiting foster to adopt families because those families only wanted children who were very young. The Librettis claim that the source of the conflict in their custody case was ICWA. It's a belief they hold so fervently that they have taken it all the way to the Supreme Court. But what if the explanation is much simpler? What if the source of the conflict was using foster care to adopt? So this is a makeshift memorial for the indigenous children who died more than a century ago while attending an Albuquerque boarding school, one of the many to which native children were sent after being partially removed from their families. So this is a memorial to kids who were lost in the residential school system that we mentioned earlier. A lot of kids died in those schools, and they are like it was in the news pretty recently that they were finding these mass graves in Canada. Empson says residential school system, aka kitty concentration camps, and concentration and camps are both spelled with a K. If the Librettis were confused about the true purpose of the foster care system, one group of people should have known better: the social workers at Washoe County HSA. In Nevada, under state law, the department is required not only to place children with relatives when possible, but also to search diligently for those relatives. In Octavia's case, Washoe County social workers did not live up to that charge. Social workers from Octavia's tribe stayed involved in her case to ensure that she would be placed with family. But from their perspective, the Washoe County HSA was resistant. In Texas, where many of the tribe's ICWA cases are based, the tribes enjoy the. I'm going to try and pronounce it one more time, but I'm sure I'm going to get this. Isleta del Sur Pueblo enjoy a great working relationship with the state, Lea Lopez said. But in Nevada, she added, they didn't understand ICWA, didn't like ICWA, and didn't enforce it. Washoe County declined to respond to allegations. Impson says, so now we get into a conflict between the social workers working for the tribe and the social workers working for the U.S. government. By mid-September of 2016, when Octavia was 6 months old, she was enrolled as a citizen of the Isleta del Sur Pueblo. By that time, the Washoe County had changed the case plan from reunification with her father to terminating his parental rights. After Octavia's uncle withdrew as a foster placement, the Isleta del Sur Pueblo social workers started looking for other family. They identified 39 relatives and gave the list to Washoe County social workers. But according to Lopez, the Washoe County caseworker didn't contact anyone on the list as required by law. Fucking hell. The tribe had to get a judge to order the social worker to start making calls. And when that social worker did start calling people, the worker seemed very pushy about not having baby O placed with family here. I wonder if that social worker had some sort of pre-existing relationship with the Librettis. Lopez, okay, instead of explaining the process or helping people fill out paperwork, the Washoe County social worker tried to talk family members out of taking the baby, according to Lopez and family members we spoke with. Oh, such bullshit. Sylvia Triest was one of those family members. She is also a citizen of the Isleta del Sur Pueblo. Octavia's grandmother is Triest's cousin, which in their family makes them akin to siblings. Triest was a single mother living with her youngest daughter, Savannah, in Las Cruces, New Mexico, when she learned of Octavia. She had just purchased a 3-bedroom home and had space for another child. Her 2 other children had gone to college and the army and were out of the house. Probably just a good Christian doing their good Christian duty of bringing heathen savages into the light, to be honest. Yep. There are people like that. I, I said, well, I'm positive that me and Savannah and the baby could be a happy family, she told me. It was not even that I had to think about it. It's just something we do as family. Priest had learned about Octavia's case from her mother, who had received a letter early on about the baby, but felt she was too old to care for a newborn. But when Triest reached out to the Washoe County HSA to say she was interested, she didn't hear back for months. In the end, Triest got the phone number for a Washoe County caseworker from Lopez and called her. But the call wasn't what Triest expected. The lady was just letting me know that they, the Librettis, were going to fight for this baby, and they've had it since the baby was born. Triest told me, and I just felt that it was already going to be a done deal. The caseworker told Triest that she could try to win custody of Octavia, but that she likely wouldn't succeed. I do know about the ICWA law and what it does for us and how it tries to keep the Indian families together, Therese told me. When I talked to them, the social worker, it didn't sound like we had a chance. The story Heather and Nick Libretti tell in their lawsuit is very different. They claim they were the only people who wanted to adopt Octavia. According to the paperwork they filed in federal court, most of the family members the tribe identified withdrew from consideration or were deemed unfit placements. I was willing to adopt the baby, Therese said when I read her the court document. Uh, again, I here is Rebecca Nagel. Let's see. And I don't know what they're saying about unfit. I mean, maybe we don't come from money like they do. Therese was never found to be unfit, and Lopez said at least one other family member finished going through the foster process, obtained her license, and even fostered other children. That family member never got to move forward with Octavia, however. After Octavia celebrated her first birthday, the tribe was still working to place her with family, but Washoe County social workers argued that moving the child now would be harmful because she had been with the Librettis for so long. The case went to mediation. According to the Libretti's declaration, the tribe agreed to let them adopt Octavia only after the Librettis joined the federal lawsuit in 2017 seeking to strike the ICWA down. But one source suggested the situation was more complicated. The source alleged that the Washoe County HSA put forward an unusual arrangement. If the Librettis couldn't adopt Octavia, Washoe County social workers suggested the child could be placed with her biological mother, but the birth mother would have custody only on paper. Octavia would actually stay with the Librettis. What? Since the birth mother was family, the placement would not violate ICWA. When asked about this alleged proposal, however, when asked about this alleged proposal, Howell, the HSA director, declined to comment, citing privacy concerns. That is so weird. Uncertain it would prevail in court, the tribe decided to settle the case. Under the order, the Librettis agreed to take Octavia down to the reservation in El Paso once every 3 years. 3 years! God. Since custody cases in Nevada are sealed, we don't know all the details of Octavia's case, but from emails received via public records requests, we know social workers at the Washoe County HSA were struggling as recently as 2021 with how to apply and follow ICWA, despite the fact that they handle a number of ICWA cases each year. So this is Madonna Papin, plaintiff in a lawsuit that charged South Dakota with violating the ICWA with her daughter, and the photo was taken in 2013. The reappearance of Octavia's birth mother in this story raises complicated questions. Alta Gracia Hernandez, or Gracie as she goes by on social media, is a plaintiff in Halan v. Bracken. She and her lawyers suggest that ICWA violated her constitutional rights by not allowing her to choose her child's adoptive parents. What? 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 Okay, when you drop your child off at a hospital, aren't you, like, giving up all of your parental rights? Don't you, like, no longer have a say? Like, I thought that's how that worked. How is that a problem with the ICWA and not a problem with the safe haven law or whatever it was called? That's what? Not actually that simple. Of course it's not. Nothing's ever simple. Ugh. Media representation of adoption is simplified to make adoptive parents look like heroes all the time. Yeah, that makes sense. The implication is that ICWA interfered with a mother's right to choose what's best for her child. I strongly oppose any effort to relocate her away from the Librettis or out of Nevada to a strange place to live with people she's never met. She's a baby! Hernandez wrote in her declaration to the court. When contacted, Hernandez declined to comment. One second. Okay. While Hernandez's position as a birth mother trying to navigate what's best for her child is sympathetic, the argument that ICWA interfered with her right to choose isn't the full picture. In their declarations and court filings, Hernandez, the Librettis, and their attorneys all fail to mention that Hernandez surrendered Octavia under Nevada's safe haven law. Such laws were created in response to high-profile cases of newborns being abandoned and even dying. Yeah, like I, oh God, I would much rather, you know, parents who can't take care of their children drop them off at hospitals or whatever instead of leaving a baby in a dumpster or whatever. Such laws were created. Okay, yeah. While the law allows parents to give up infants without fear of prosecution for abandonment, it also requires them to relinquish their parental rights. While the law does allow parents to regain custody under limited circumstances, Hernandez got involved in Octavia's case to support the Librettis, according to her federal declaration, not to regain custody herself. When Isleta del Sur Pueblo citizens are adopted, whether by members of the tribe or by non-natives, the tribe holds a big ceremony, and it did so for Octavia and the Librettis. It was just a traditional ceremony. Our cacique? Cacique? Our chief, did a blessing over the family and over baby O, Lopez told me. And then we had the kids from our pre-K. They came down and did dances for her. Octavia's extended family was invited, and many came. Treese drove down from New Mexico with her aunt. But for them, it wasn't a celebration. That was the saddest thing, to see her and see how much she looks like family, Treese said. On the car ride home, she and her aunt cried. I'd probably cry too, Jesus Christ. Oh. I asked Treese if she ever regrets not fighting harder to adopt Octavia. Yes, I do. I do. I really do, she told me. I regret it because I feel the baby would have been more at home being with true family and true blood. With a native Tigua family. Under the custody agreement, the Librettis will continue to take Octavia to visit her reservation in El Paso once every 3 years. According to Heather Libretti's social media, they last visited in June 2022. On Instagram, she called it a great cultural experience for Octavia. In her federal court filings, however, she alleges the visits are a financial burden. Of course. Of course. The tribe helps out, let me just say that, Lopez told me. The tribe helps out with financial costs. Lopez maintains contact with Heather Libretti. She was nervous about discussing the details of the custody case with a reporter because she didn't want it to damage the tribe's relationship with the adoptive couple. I've never doubted for a second that the Librettis love her, but it was really hard for us, having a child that belongs to our tribe stay with a non-tribal family. Heather was given this little girl thinking it was a done deal, and it wasn't. And so I can understand what came from that. I do wish things were probably explained better to her during the initial stages of the custody case, but it is what it is, and we just want to move forward. Heather and Nick Libretti have split up. They've split up since filing the lawsuit. Oh, wow. Heather now works at the Human Services Agency. Of course she does. So maybe I was right. Maybe that this social worker did have a pre-existing relationship with the Librettis, because she's working there now, and they've split up. So wouldn't that like be a mark against them if they were trying to adopt? Because I like the way that I have like I've always been told that it's harder to adopt as a single parent. Yeah, I know it's done. I just think it's uh the Supreme Court will likely issue its ruling in Howland v. Bracken in the late spring, potentially overturning the law, and with it, the futures of scores of Native families. One family it will not affect, however, is the Librettis. The outcome of the lawsuit will not change who raises Octavia because her adoption is final. One might have thought the Librettis would have been satisfied that they won custody, but they are still suing the federal government to strike down ICWA. I wonder if they're being paid. One of the big questions raised by the Libretti's legal opponents is whether or not they should be able to bring the case in the first place. Normally, to have standing in federal lawsuit, a plaintiff has to prove, among other things, that they experienced harm as a direct result of that law and that winning the lawsuit would fix that harm. The harm the Libretti's claim that it is not that ICWA prevented them from adopting Octavia, but that it made the adoption harder. This claim is a little odd. It's like a white college student suing a university over its affirmative action policy after the student was accepted by the school. In order to have a case in federal or state court, you have to have controversy. University of Michigan law professor Matthew Fletcher explained. With the controversy here, the custody dispute has been settled. In fact, all of the underlying custody cases in Bracken have been finalized and won't be affected by the Supreme Court's decision. The case is moot completely, Fletcher said. Yet Howland v. Bracken is still moving forward. The narrative that ICWA disadvantaged the Brackens, Cliffords, and Librettis is an upside-down version of the truth. The native children the plaintiffs sought to adopt entered foster care because their biological parents had substance use disorders. All the native children had an extended family member who wanted to raise them. Every native relative got pushback from a social worker, foster parent, family court judge, or all three. Compared with the white foster parents, the native family members faced more hurdles in these custody battles. In the end, only one grandma was able to adopt her granddaughter, child P, after fighting for 6 years. 6 years! Christ! To argue the placement was inappropriate, the plaintiffs told federal courts that the grandmother's foster license had been revoked, but that never happened, as we reported on This Land. These three cases tell a story worthy of national attention, but that story is not that ICWA disadvantages non-native foster parents. Rather, it's how, in a biased system, native families still struggle to keep their children. Yeah. So Imson says, notice how consistently white folk just stay lying. Throughout these events, it's just lying to cover lies. Yep. God. At a time when the Supreme Court is hearing challenges to affirmative action and civil rights legislation, Howland v. Bracken could help lower the bar of what constitutes legal harm when it's experienced by white people. Ugh. The Librettis and the Brackens got what they've wanted, but for a period of time worried that they wouldn't. If that's enough to undo a decades-old law protecting millions of native families, what legislation protecting the rights of the vulnerable is safe? Because issues affecting Native American rights rarely make headlines in this country, it is unlikely Burkine will be one of the closely watched blockbuster cases in this term. But it should be. The Burkine case is a test for the Supreme Court, and everyone concerned about the integrity of the High Court should be watching. Will the court follow decades of court precedent and centuries of federal law that say Native Americans are a political, not a racial category? Will the court follow the rules of civil procedure and challenge whether the individual plaintiffs have legal standing? And will the court seek out the truth in a case where plaintiffs misrepresented the underlying facts? Given the court's very mixed decisions on tribal sovereignty in these past terms, it's difficult to say. Ibsen says, i.e., how far will our current government stretch its own rules in order to advance white supremacy? I don't think there's a limit to that, honestly. Whatever the outcome, Howland v. Burkine will either demonstrate the court is still tethered to federal law, court precedent, and the rules of civil procedure, or it will show that the court is so unmoored that even truth no longer matters. So, Rebecca Nagel is a citizen of the Cherokee Nation. I think there's Cherokee in Mississippi, Cherokee and Choctaw. Anyway, I'm going to listen to this podcast. So yeah, that's the ICWA, which I think is very, 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 very important. Is under threat. I'm not happy about it. Anyway, I just wanted to take some time to talk about that. If there's any, just if anyone in chat has any questions, I guess, or if any comments. I'm gonna skip this song. All right. So I'm going to be clipping this into a Twitch highlight, and eventually it'll make its way to YouTube. Because like I said, I think this is pretty important. I might be doing this kind of thing more often, where I take a break from the stream to talk about important stuff. Because I'm bringing these issues to an audience that doesn't normally get to hear them, and I think that's important.